is Chicago's Morning Answer with Dan Proft and Amy Jacobson. This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. So the Fisher case before the High Court, oral arguments. This is related to 1512 C2 of Sarbanes-Oxley, the official or the criminal interruption of a official proceeding. That is the statute that federal prosecutors have used against many of the January 6th defendants and President Trump. So this is an important case. This exchange between Justice Neil Gorsuch and representing the Biden administration is Solicitor General Elizabeth Prelogar. This exchange is important, and we want to get our next guest to weigh in on it, since we have one of the most brilliant legal minds joining us, Richard Epstein, momentarily. Take a listen to Gorsuch's challenge to the application of this federal statute to J6 defendants and, by extension, President Trump.
If I might, so what does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
There are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations, or the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512 C2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means that if you have some minor disruption or delay or some minimal outburst, we don't think it falls within the actus reus to begin with. My outbursts require
the court to reconvene after the proceeding has been brought back into line, or the pulling of the fire alarm, the vote has to be rescheduled, or the protest outside of a courthouse makes it inaccessible for a period of time. Are those all federal felonies subject to 20 years in prison?
So with some of them, it would be necessary to show nexus. So with respect to the protest outside the courthouse, we'd have to show that, yes, they were aiming at the proceeding.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
We went around that tree yesterday.
I know. I heard the argument yesterday, but I guess what I would say is that to the extent that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of those protesters had corrupt intent.
So mostly peaceful protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Not necessarily. We would just have to have the evidence of intent, and that's a high bar.
They intend to do it all right.
Yeah, they intend to do it all right. So when Jamal Bowman pulled that fire alarm and Congress had to be evacuated, he intended to do it. He didn't confuse with the door handle or whatever nonsense he came up with. And so the vote had to be rescheduled. That's the example, one of the examples that Gorsuch is referring to. Sit-ins at a trial. So the Kavanaugh protests, disrupting a nomination hearing. Hecklers in the crowd. Think of all the pro-Hamas protesters disrupting all kinds of events, canceling all kinds of events.
Oh, yeah.
The BLM protests, disrupting, canceling events. And this, this corrupt intent. Well, I would have also challenged her. So give me an example where something like the examples I provided occurs where there wasn't corrupt intent, meaning intent to disrupt, intent to prevent. What was it? what was it otherwise in all of these actual real-world incidents? And so distinguish that from those charged with federal crimes under this provision of federal statute that are facing 20 years in prison when they want for wandering through the Capitol. Some not even in the Capitol, on the grounds, and did otherwise not commit a violent act. It'll be very interesting to see how 1512 survives or doesn't when the court renders its opinion on this. For more on this and other matters, we are going to talk about the Obama Presidential Center in Jackson Park as well. And by the way, but before we bring Professor Epstein on, I just want you to think about this. You're about to hear from Professor Richard Epstein. Mm-hmm. He turns 81 years old today.
I know. It's his birthday, and we love birthdays here at AM 560.
Please don't sing. And Joe Biden is also 81 years old. So think about Joe Biden at 81 and Richard Epstein at 81 and just enjoy the distinction. I'll just say that. Professor Richard Epstein is the James Parker Hall Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago. Professor Epstein, thanks for joining us. Appreciate it. Happy birthday.
Thank you for the happy birthday. As you get older, each year becomes more precious.
Well, we're glad
Yes.
you're spending your time with us today.
Yes.
It's a birthday.
Right. You can have a birthday cocktail after this interview. So that exchange with Gorsuch and the federal government's lawyer on 1512, with the implications it has on so many of these J6 cases and potentially Trump's cases as well. Give us your read on that exchange.
Well, my view about this from the beginning has been they've always charged things far too heavily because they're largely political trials. And every time you hear Alvin Bragg or Letitia James or even Merrick Garland say, we follow the law, just the law, and only the law, you know that they're doing precisely the opposite. It's ridiculous to take financial situations where you're trying to build people millions of dollars and apply it to situations where the other statutes, which are directly applicable, having to do with entry, which is unlawful or unpermissible, have much more restrictions in terms of the proof of the liability and, in fact, much lower sanctions. So I regard this as utterly irresponsible. A prosecutor on a case of this moment has to be very sure of their legal theories. And what they're doing in this case is pushing it as far and as hard as they possibly can. And what they say is, what do we have to lose, is their attitude. We go for this stuff. We want to get 20 years in prison for 4 minutes walking inside the building. We're going to basically take every ambiguous effort with respect to the use of force, never knowing who pushed whom when, and put it up to 20 years. This is utterly unforgivable in the way in which one ought to be running a justice system. It's not uncommon. Mr. Brass, it takes a routine kind of case of financial integrity, not anything having to do with the steamy sides of matter, and he breaks it up into 34 causes of action and says, I could get this guy for 50 years, but I'm only implying the law. You got prosecutorial discretion, and the most important thing for prosecutorial discretion is to make sure that when you get a case of great moment, that your legal theory is rock solid and your evidence is rock solid. And in this particular case, they're going hell for leather. The argument is, if I lose on this thing, I may be disgraced and perhaps influenced, but I could get the same cases I had before. So they treat this as a no-win prosecution. But it may be no win for them, but it's certainly a desperate prosecution for everybody else on the other side. And what it does is it takes the entire criminal apparatus of the United States and calls it into question. So what you do is you have a crisis of legitimacy because you get over pushing on all of these kinds of cases. It's a very, very dangerous type of situation. And I think the only thing that you have to say, they should have never done it. And I think the Supreme Court will slap them down. In my view, it could even be 9-0.
But that slap it down will come in what form? I mean, will they declare that provision of Sarbanes-Oxley unconstitutional, or will they just say this is a misapplication?
It's only going to be the latter. I mean, surely obstruction of justice can take place. Mm-hmm. And if you start, shredding commercial documents in order to clear your various kinds of offenses, as far as I'm concerned, that's very serious and ought to be treated accordingly. Mm-hmm. But the word corruptly means that you sort of do it without any kind of legal justification, right? And in all the cases that you saw of sit-ins and so forth, there was no argument whatsoever that you can do it. This is not the case of somebody entering into the Capitol to save somebody who's burning or in a serious medical condition and trying to take them out. Those kinds of removals, even if they're trespass, would be justified on some kind of a doctrine of necessity to save the life and health of other individuals, and therefore would not be deemed corruptly. But the burden is upon the government, let's put your point in more technical terms, is the moment you should show a deliberate intention to disrupt procedure, the burden then has to be on the other individual to prove that he had a legitimate motive. Otherwise, the simple proposition is an intent to disrupt various kinds of proceedings will be regarded as corrupt, right? And so they are basically pushing this thing so far. It's just not a very wise way in which to proceed. They cannot win this particular case. As far as I'm concerned, they're just going way, way over the top.
Well, that and by the way, I'm sure that's the same sort of in-depth legal analysis we would have got from Joe Biden, who's also an attorney. Yeah, thank gosh we have you in the absence of Joe Biden. So that necessarily means that there are going to be all sorts of convictions overturned.
Yeah, because what they're doing is they're over-pleading on the obstruction ground. As I said, I mean, in these particular cases, you have fairly stringent requirements, and all they can show about these guys, they're walking in the building, and somebody bumps into somebody else. The facts in this particular case are extremely strong for the defendant, and it's just tiresome to constantly hear people who are, supposedly the forces of law announce that they have no political motivation. They're only doing this to enforce the law. The most important doctrine to remember in this particular case is that of selective prosecution. The government always has some degree of prosecution. If they select people for political reasons, it's against the FBI manuals, against everything else. That's just being done in all of these cases. Look, I'll give you another analysis. You want to find some really ugly stuff? There were people who managed to occupy for long periods of time government facilities in Seattle and Portland. Willful destruction of property, right? And they never got charged. They were all released on their own cognizance. It's the asymmetry. People may not know what's right or what's wrong in all cases, but what they do understand is unfair treatment, where you really slam your enemies and you let your political friends go free. That's exactly what has happened in this particular kind of case. So I don't think it will stand. I think it's going to be, the whole thing will be blown up. And indeed, I mean, I can tell you what are the charges make that some sense, but in every case, even if there's some guilt, like with Mar-a-Lago, there are greater guilts on the other side, like Hillary Clinton, and the sanctions that they're asking for are much too heavy. And so the prosecutorial discretion is going in overdrive. And my view is it's likely to elect Donald Trump as president of the United States, because when the president starts talking about we have to make this nation safe for democracy, what he really should be saying, you have to make this state safe for democracy by keeping me out of office. Because I'm managing to violate every particular norm that you could imagine.
I wanted to get the latest on your litigation in conjunction with Protect the Parks on the Obama presidential complex. You are pursuing a rehearing in federal circuit court. Where does this stand, and what's your assessment of your own case at this point?
Oh, I mean, we've had a thundering stream of big debates, and every case that we've lost, I thought, was essentially very badly argued and very badly decided by the bench. So if you're just predicting to be more of same, given the enormous political clout that Obama seems to be able to exert over the entire legal system. But if you look at the opinions and try to figure out what's going on, the first thing you should do is look at the statement that the Obama Presidential Center writes when they're actually forced to confront this thing by my column in the Chicago Tribune with Michael Ratcliffe being put in the Wall Street Journal, best on the stuff. And what they just do is they take a page out of their manual and they say, the Obama Center is designed to do everything that's just wonderful. Just to give you one kind of practical illustration, we don't know what the cost of this thing is. And it turns out, as best I can estimate from the very fragmentary information that they have available, there are at least $1 billion in the hole in trying to put this. And we're told by the court that we're suing as third-party beneficiaries. It's just an outright falsehood. The first thing we said in our complaint is this is not a third-party beneficiary case. We're not suing on this contract. We're saying this contract should have never been made and it's a breach of public trust. It's a completely different kind of argument, and Judge Wood just completely mangles the thing and says that's not what it's at. You open this stuff up and you look underneath, well, what are you going to find? You're going to find that it turns out their estimates as of September 2021 left them in the hole by at least $1 billion. They had a building that was going to cost $700 million, and they had nothing to pay for it. And they had an endowment fund of $470 million, and they put $1 million in it and said, well, we satisfied our endowment. But they have to fund all of these things. Right. And they have no way to raise the money at this particular.
Well, one of the other things is one of the other things, though, too. It seems to me is that's unconscionable. So the contract is unenforceable. Is the acquiring the land that you suggest is probably worth $10 million an acre for $10.
Yeah, I mean, but
who gets a deal like that?
Only one person, as we know. And what are they putting in the center? We don't even know the floor plan. There's said to be floors devoted to the residents of the Obamas. There's going to be a convention center. There's going to be a cafeteria. There's going to be a souvenir shop at one point or another. And there's probably going to be office spaces. So my guess is if you could actually see the plan, say maybe 25% of it is devoted to public exhibits. I mean, I have no idea what's going on because the man who always prizes public transparency just basically plays rope-a-dope and doesn't reveal any kind of information about anything that's going on. You look at the logistics of this building and they're a nightmare because you have only one entrance and it has to service 4 different functions. They have the huge security apparatus that they have to run. They got all their employees. They got all their suppliers and all their customers coming in through the same door. If they put it elsewhere, it would have been a very much more attractive building. We designed a building for them, world class, which they didn't look at because what Judge Wood said, we don't have any power to stop this. And what we did 1,000 times is, Judge, you're right. The federal government doesn't have to tell them they have to run the project. It doesn't tell them they could locate it somewhere else. But the whole purpose of an environmental statute is to say if there's certain things that you can't do because they've been done well elsewhere, you can block it and then let them decide what to do thereafter. She says the original project may have said we're examining the Obama Presidential Center in Jackson Park, but no, they changed the rules 15 months later and say all we're doing is looking at the road work at the edge of the park. And they say, well, the only way that you can handle this monstrosity in the middle is to essentially shrink the park and to widen the road. And then, of course, it just takes longer and longer. In her opinion, she said, well, they estimate October 2025. By the time the opinion was published, the date was now February, March, or April of 2026. You look at the building, it's a kind of a standing joke that we all have, is there are always the cranes there, but you never see them moving. Then the next day, they're in a different position, so you know that they have to move. And so and my wife drives by and she looks at it. And she said, and no windows in this building. What's going on?
It's so ugly.
Said, well, it's beyond ugly. Because what happens, they have no idea. What they do is they give you all these close-ups of people walking on the lawns in front of it. But they put it in the middle of the midway so as to have this spectacle. And what it looks like is there's a fortification to prevent aliens from landing on the shores of Lake Michigan and taking over the city.
And where are people going to park?
There is. They will put a parking place. No, I think the real question is partly that. Are they going to come? They could park at the Museum of Science and Industry, and they have to build this parking place for their employees and so forth. But they will have, I think, 375 spaces, and there'll probably be spaces for 100 people in the public. Nobody is going to come there and drive. They'll take some kind of other vehicle, or they'll go to the museum. And in terms of business to Hyde Park, if there's one customer out of 100 that walks from the situation in the OPC to any of the restaurants in Hyde Park, it will be a minor miracle. They keep on boosting the huge economic stimulus it would give. And the great tragedy is that they put this thing west of Washington Park. They could have put it on land that was not public trust land. They could have had a glorious building. They could have had really nice access to the Green and the Red Line and to the Line Expressway and Martin Luther King Drive. And what they did is they put it into a place where it becomes utterly inaccessible, and it will not be any kind of stimulation whatsoever for the community that it's supposed to serve.
Yeah.
This thing is a travesty from start to finish. And what Obama Center should really do is say, well, we may not have to disclose this stuff because we've given this protection. But this is what our building looks like. This is what our budget looks like. Are we on time? Are we over budget? They won't reveal a thing. Valerie Chapman, all she does is she takes the publicity and answers all the specific charge with sentences that begin, our focus through this legal journey has been to protect the interests of our community. Blather,
Yeah,
blather,
right.
blather.
Yeah.
Right, blather, blather, blather. Well, because of the subtext is, we want what we want, and when and where we want it, and if you don't like it, so what? And that's well, but do check out Professor Epstein's op-ed in the Chicago Tribune as well. James Freeman in the Wall Street Journal picked it up and discussed it as well. Professor Richard Epstein, James Parker Hall, Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago. 81 and sharp as ever. Professor Epstein, thank you so much for your time. Appreciate it.
It's always a pleasure.
And have a blessed birthday. And he joined us on our turnkey.pro answer line. Coming up on Chicago's Morning Answer, they took a trolley. We'll explain, but now let's head into the newsroom. Here is Mike Scott.
It's 8:30 on AM 560, The Answer. Local officials say 3 Russian missiles have slammed into the downtown area of the northern Ukrainian city of Chernihiv, hitting an 8th-floor apartment building, killing at least 14. Jury selection process resumes Thursday after 7 jurors were